An overriding legal concern with scored tests in employment is that they can produce disparate impact discrimination. Although the tests are neutral requirements, assuming that the same tests are given to all candidates for the same jobs and are scored in the same manner, they may nonetheless have discriminatory effect. To watch for discriminatory effects, applicant flow data compares the protected class composition of an applicant pool to that group of people who pass the test and are eligible for an employment opportunity. The underlying premise is that although individuals vary widely in their abilities, overall, people of different races, sexes, national origins, and other protected classes are equally capable of doing most jobs. Thus, we would expect that men and women, or whites and blacks, should have similar rates of success in passing the tests and obtaining employment opportunity. If instead, men pass the test at a much higher rate than women or whites pass the test more often than blacks, such an outcome indicates that some aspect of the test is producing discriminatory effects. How different must test outcomes be to conclude that discriminatory effects or disproportionate selection are occurring? One simple guideline is the EEOC's 4/5 rule. The rule says that if the selection rate of one race or sex or other protected class group is less than 80% of the group that was most successful at passing the test, that result constitutes evidence of discriminatory effect. The 4/5 rule is a useful rule of thumb and is given some deference by the courts, but it does not always suffice. It can be misleading when the number of applicants is small. In one case, pass rates for whites and African Americans on a promotional test for firefighters violated the 4/5 rule. But because the number of candidates taking the exam each year was so small, there was not a prima facie case. In another case, selection rates on an exam satisfied the 4/5 rule, but other statistical methods showed that the difference in the mean test scores between white and African Americans was still far larger than would be expected by chance. The plaintiffs were thus able to establish a prima facie case. When cases go to the court, expert witnesses are typically called to present more sophisticated statistical analysis. The techniques used vary, depending on the groups compared and the sample size, but they share the aim of showing that any differences in selection rates or scores for protected class groups are statistically significant. This means that results are highly unlikely to occur by chance, usually translated as an outcome that would be expected to occur no more than 5 out of 100 times if there were not a true difference in selection rates or scores. Employers need to monitor and record the effects of testing procedures on different protected class groups. The 4/5 rule should be applied to selection rates generated from applicant flow data to identify possible discriminatory effects. Tests with discriminatory effects should not be used unless strong evidence of test validity exists and less discriminatory alternatives are not available. It's important that potential disparate impact and the defensibility of tests be considered at the point when tests are being designed or purchased by an employer.